Colin Manning here again. In this video, we're going to look at the obligations of data controllers and data processors. Now, some of this will feel a bit repetitive because, of course, if there is a right of the data subject to have access to A, B, and C, then there's a corresponding obligation on the controller and the processor to provide A, B, and C. So there's a lot of what seems like duplication there. So let's take a look now then at Chapter 4. So Chapter 4 steps back a bit from the data subject and focuses on the data controller and the data processor and talks about what their roles are and their obligations. The data controller and data processor have obligations to the data subjects. So some of their obligations are mirrors of the rights of the data subject, but the data controller and data processor also have obligations to the supervisory authority. We'll talk a little bit about those. And of course, the data controller and data processor have relationships between them as well. And the data processor has obligations to the data controller. So Chapter 4, Section 1 talks about the general obligations of the processor and the controller. Looking at Article 24 then, we deal with the responsibilities of the controller. And the controller has quite a number of responsibilities. Article 24.1 sets out some general principles about the responsibilities of the controller. And a key element here is the appropriateness of the measures. Taking into account the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for the rights and freedoms of natural persons, the controller shall implement appropriate technical and organizational measures. Now, this is important because the controller is expected to assess both the likelihood and severity of issues that might crop up. And so this can depend on the type of data that's being stored, how sensitive the data is, and then the controller is expected to speculate as to the severity, if there was a breach, for example. But it's about appropriateness, and we'll see this again and again in the GDPR. It takes a risk analysis approach. You know, you can have very high impact, low probability events. You can also have lower impact, higher probability events. So the structures, be they technological or organizational, that are put in place will reflect the nature of the risk. Now, the controller will also be expected to demonstrate then that the processing is performed in accordance with the regulation. So the balancing and the calculation and the plan will have to be documented. Article 24.2 states that where proportionate in relation to processing activities, the measures referred to in paragraph 1 shall include the implementation of appropriate data protection policies by the controller. So there's a proportionality here. So if the information is, shall we say, low value, and if a breach of that information would have few or minor consequences for the data subject, I mean, it's not that you don't have to treat that data with respect and follow the rules, but your measures should be proportionate. Whereas if you're storing very significant information, very important information, health information or financial information, well, then you will obviously need more security. There's a proportionality there. Article 24.3 talks about codes of conduct and approved certification mechanisms. These are still, I think, in the aspirational stage, but the idea was that as a data controller or a data processor, but mostly as a data controller, you would sign up to a code of conduct So the hope was, say, that professional bodies or industry bodies might develop codes of conduct for their members. And these codes of conduct would be written by experts who would analyse the kind of data that the industry body members were using. They would analyse the risks, and they would produce then a strategy and a plan and a code of conduct for the members of that group. And you can see why this would be useful, because depending on what you're doing, depending on the line of business you're in, you'll have different kinds of data, you'll have different needs, you'll have different wants. But people in the same industry would have the same needs and wants and the same kinds of data and the same issues. So you could imagine a scenario, just to make something up, the Association of Dry Cleaners of Ireland might come up with a code of conduct for its members, and then members could sign up to that code of conduct and they would know then that they are good to go. So this is referred to actually later on in the GDPR, but that's the idea behind that. And so one of the ways that the controller can demonstrate that the organisation is good to go is adherence to one of these codes of conduct. Article 25 talks about data protection by design and by default. And the idea here is that when systems are being designed, data controllers should build data protection into the system from the beginning. So rather than designing a system and then saying, okay, now we have to think about data protection and have data protection and privacy bolted on, they should be designed in from the beginning. So rather than data protection and privacy being the icing on the cake, it should be baked into the cake. Again, now this is expected to be proportionate. So the controller is supposed to take into account the state of the art and the cost of implementing whatever schemes, whatever plans are in mind. And also there's the nature, the scope, the context and the purposes of the processing. And in particular, the risks of varying likelihood and severity. So again, we're talking about a risk analysis here. You can see too that the framers of the GDPR were not prepared to pin down any particular technological measures or any particular state of the art at a particular time. So it's taking into account the state of the art. So in 10 years' time, the state of the art could be quite different. And the GDPR expands the obligations of the data controller as the technology and as the means expands. Article 25 does specify two specific techniques. The first is pseudonymization. Every time I see this word, I want to say pseudo-anonymization because it's kind of like anonymization, but pseudonymization is the correct word. It's not a typo. And this is a topic we might discuss later in its own right. Pseudonymization is the practice of removing the personal identifiers from the data and then perhaps storing that separately somewhere else. So any processing that might be done on the data can be done without actually referencing the individual person. A good example would be processing of examination results. So it's possible for students to use just their ID number on their examination scripts or on their submissions. And all of the processing of exam results that needs to be done could in fact be done without any reference to the student's name, just the ID number. Now, obviously, at the end of the day, for students to get their results, there has to be a table somewhere that connects these students' identities to those numbers. But if an exam script or an assignment or examination results somehow escaped and were somehow released, well, people wouldn't know who the actual student was. So you could see how it's possible to design a data processing system with pseudonymization built in. Importantly, pseudonymization is not the same as anonymization. a table somewhere connecting the names and the identifiers still exists. But the idea is you could store that much more securely. You could limit access to that. You could have enhanced technological measures for protecting that. But you could be slightly more relaxed with the pseudonymized data. Another technique that's also mentioned specifically in Article 25 is data minimization. One way to protect users' data is to just have less of it. When you're designing your system, you can ask yourself, well, do I really need this data? And then only take the data that you need. If you need to know for your purposes what age someone is, for example, well, maybe you can just store the year of birth instead of the full date of birth. Depending on what you're doing, that might be enough. If you need to store where someone is from, maybe all you need is the county, or maybe all you need is the electoral district. Perhaps you don't need the full address. In the UK, for example, it's quite common to use the postcode to give the general area that someone is in. You have to bear in mind, of course, that in Ireland, the postcode identifies a specific home. But I've already seen people looking for, say, the first 3 digits of an Irish postcode. That gives them some of the information they need without pinpointing an actual address. These are different techniques that can be considered, but what Article 25 is suggesting is that these protections could be built in when the system is being designed, and these protections should be in place by default. I noticed, for example, that the microphone I'm using to record this video is set to mute by default when it's powered up. So when I connect up this microphone, it's by default on mute, and I have to physically push a button to engage it. So the person that designed this microphone was thinking about data protection and privacy by design and by default. So Article 25.2 addresses the default issue in more detail and suggests things like that only personal data which are necessary for each specific purpose of the processing are processed. So you only process as much as you need, that you only collect as much as you need, and you only store it for as long as you need. And that these protections should be in place by default. Article 25.3 points out that you can use signing up to one of these certification mechanisms that are mentioned later to demonstrate that you're complying with 25.1 and 2. Skipping ahead then, the next thing that we're interested in is Article 28. And so Article 28 talks about the processor. So you'll recall we have 3 main actors in our data protection scheme. We have the data subject, and that data subject is having his personal data processed by a data processor on behalf of a data controller. So the controller might be a bank, the data subject might be a customer, and the data processor might be some third party that does IT processing stuff. So where processing is to be carried out on behalf of a controller, the controller shall use only processors providing sufficient guarantees to implement appropriate technical and organizational measures in such a manner that processing will meet the requirements of this regulation and ensure the protection of the rights of the data subject. So it's anticipated that the controller might farm out some processing to a data processor, but the controller must ensure that the processor meets all the obligations of the GDPR. And the controller is responsible at the end of the day. If it all goes horribly wrong, it's the controller that will be on the hook. So if you are farming out processing, you have to make sure that the processor is legit. Furthermore, the processor shall not engage another processor without prior specific or general written authorization of the controller. So if the controller farms out some processing to a data processor, that processor is not allowed to further subcontract out that without the permission of the original data controller. Now, Article 28 then discusses some of the specific provisions that will be in the contract between the data controller and the data processor. Some of these go without saying, and of course a contract will also include some commercial provisions and perhaps some other provisions, but at a minimum, in order to comply with the GDPR, the contract between the controller and the processor will contain these things. It will stipulate that the processor processes the data only on documented instructions from the controller. So any processing that will be done on the data will be done on the specific and documented instructions from the controller. So they'll have to be in writing. The processor ensures that persons authorized to process the personal data have committed themselves to confidentiality or are under an appropriate statutory obligation of confidentiality. So you can imagine a scenario where the people working for the controller have agreed to treat the data as confidential, or there may even be a legal obligation on them to keep it confidential. But if the processing is subcontracted out to a processor, well, the people who work for the processor must also be subject to confidentiality arrangements. Article 28(3)(c) says that the processor must take all measures required by Article 32. Article 32 talks about security. The contract must also stipulate that the processor respects the conditions referred to in paragraphs 2 and 4 for engaging another processor. So we've just seen 2, we'll see 4 in a minute. But the processor must agree not to further subcontract out the processing. The contract must state that the processor will assist the controller by appropriate technical and organizational measures for the fulfillment of the controller's obligation to respond to requests for exercising the data subject's rights. So obviously, if there's an access request or other request from a data subject, the processor must agree to help the controller meet those obligations. The processor will also be required to assist the controller in assuring compliance with the obligations to Articles 32 to 36. 32 to 36 deal with security and with breach notifications and stuff like that. The contract must also state that when the contract ends, when the service being provided by the processor is no longer required, that either all of the data is returned or deleted. And of course, the choice of deletion or return will depend on if there's work been done on the data set, for example, well then the controller might want it back, in its new form. But of course, if the controller already has a copy of everything the processor has, deletion may be the preferred option. But this will have to be written into the contract in advance of the processing. The processor will also make available to the controller all information necessary to demonstrate compliance. So like the controller, the processor will have compliance issues and will have various documentation that needs to be produced and maintained and various logs that will need to be available. And of course, these will have to be made available to the controller if the controller needs to demonstrate compliance. Now, Article 28(4) then talks about what will happen if there's further subcontracting. So we have a situation where the controller has contracted out data processing to a processor, and then that data processor has further contracted out some of that processing. Interestingly, the processor shall remain fully liable to the controller for the performance of that other processor's obligations. Article 28(5) talks about approved codes of conduct that are mentioned in Article 40 and certification methods in Article 42. We've mentioned these briefly already. So again, the processor can sign up to these, and that can be used to demonstrate compliance. Now, the GDPR was very clear on the distinction between the data controller and the data processor. And the data controller is the entity that determines the purposes and the means of the processing. So the data controller is the decision maker, and the data processor is just a workhorse that executes the data controller's commands. Article 28.10 says that if the processor takes on decision-making functions, well, then the data processor will be considered a data controller. And so in that scenario, the data processor then is not just a processor in the eyes of the controller, but the data processor is also a controller in the eyes of the GDPR. And so any obligations and liabilities and penalties that might apply to a controller will end up applying to the processor. So a data processor should never exceed the brief given by the data controller. Now, given the distinction between the data controller and the data processor, Article 29 sort of goes without saying, but it says that the processor, or any person acting under the authority of the controller or the processor who has access to the data, shall not process those data except on instructions from the controller. So the processing can only take place on instructions from the controller, or unless there's some law requiring the data processor to do it. Article 30 talks about records of processing activities. So records must be kept of the processing that's taken place, and logs need to be kept of who got what. So each controller shall maintain a record of processing activities under its responsibility, and that record shall contain all of the following information. So the name and contact details of the controller, the purposes of the processing, a description of the categories of data subjects and of the categories of personal data, the categories of recipients to whom the personal data have been or will be disclosed. So who is going to get this information? Where applicable, transfers of personal data to a third country. That's an issue we'll discuss a little bit later, but there's very specific provisions around transfer of data outside the EU. Where possible, the envisaged time limits for erasure of the different categories of data. So you're already thinking about when is the end of the life cycle of the processing, when is this data going to be deleted. The idea that it'll be there forever is simply not on. That's not going to fly. You must decide when the data is going to be deleted. And where possible, a general description of the technical and organisational security measures referred to in Article 32.1, which we're going to look at in a second. And note, it does say a general description. Obviously, you don't want to reveal all of the detail of the security measures that you have in place. You don't want that outside the organisation. Clearly, you'll have to document all of your measures internally, and they may even be, need to be made available for inspection. But also in terms of meeting your obligations, you will want a somewhat redacted document that will allow people who need to verify that you do have decent measures in place to know what they are, but without the details. The processor then will also have to maintain a log, so to speak, and will need to document the name and contact details of the processor, the categories of processing carried out on behalf of each controller, again information about the transfers, and where possible a general description of the technical and organisational security measures. And interestingly, of course, from a regulatory point of view, the data controller's information had better match the data processor's information. If the data processor is processing categories of data that the data controller hasn't specified in the controller's documentation, well, then there's an issue there. So in Article 34, we see that the controller and the processor need to make that record available then to the supervisory authority on request. But there is an interesting exemption. In 35, we see that the obligations referred to in paragraphs 1 and 2 shall not apply to an enterprise or organisation employing fewer than 250 persons. So if it's a very small business, some of the obligations are excused. Unless, of course, there is processing that might result in a risk to the rights or freedoms of data subjects, or if the processing includes sensitive data. Some small organizations have taken this to mean that if they've got less than 250 people, they're kind of off the hook, but one does have to be careful about the kinds of data being processed, because even a small organization could be caught in that net depending on what's happening. Now, Section 2 of Chapter 4 of the GDPR addresses security, but as we'll see, in a not very specific way. And it also deals with breach notifications, and that includes notifications both to the supervisory authority and to the data subject. And the notification requirements are actually quite specific. Article 32 addresses the security of the processing, and as we can see here, it's written in quite elastic language, the scope of which could expand as technology and security measures and techniques evolve. So taking into account the state of the art, the costs of implementation, and the nature, scope, context, and purposes of the processing, as well as the risk of varying likelihood and severity. So again, we're back to cost-benefit analysis, looking at the risks to the data subject, and then putting in appropriate measures. And the article goes on to give some suggestions. So we have pseudonymization and encryption of personal data, the ability to ensure the ongoing confidentiality, integrity, availability, and resilience of processing systems and services. One we often forget here is the availability and resilience. We can be very focused on the confidentiality and on the integrity, ensuring that no one gets in to view the data or to change the data. But of course, we also have to worry about the system being available. If people are to make access requests, then we need to be able to access the system. So Part C follows on from this, the ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. So although it's crouched in non-technical language, this is saying how long is it going to take you to get your systems back up if there's an issue? How long will it take you to restore from your backups if there's an issue? All this needs to happen in a timely manner. We should also have a process for regularly testing, assessing, and evaluating the effectiveness of technical and organizational measures. So this isn't a thing that you do once and check the box and you're good. Your systems should be evaluated regularly. So Article 32 goes on then to address the question of what is the appropriate level of security. And it says that account shall be taken, in particular, of the risks that are presented by processing, in particular from accidental or unlawful destruction, loss, alteration, or unauthorized disclosure of or access to personal data, transmitted, stored, or otherwise processed. So there's a shopping list here of things we should consider. So what will the effects be on my data subject if some data is accidentally destroyed? If this is someone's credit history, some of their payments missing could be a serious problem. What about accidental or unlawful alteration? If your place on the league table in the squash club is unlawfully altered, that's not a big deal. If someone alters your credit history, that is a big deal. If someone alters your medical records, that could be life-threatening. What about unauthorized disclosure? Again, that will depend on the kind of data that's being disclosed. So you have to evaluate your data against these criteria. 32.3 again mentions these codes of conduct that are mentioned in Article 40 and 42. They're really pushing these, and there's still a ways to go on those. Article 32.4 seems like duplication because we've already said that the processor isn't allowed to process data apart from when instructed by the controller. But this is talking about any natural person. So this is drilling down to the human level and just making sure that individuals who work for the processor don't take it upon themselves to process any data. And of course, that processing could include revealing some things that they see even. So this talks about getting down to the human level and making sure that the individuals who have access to the data respect it. Those human employees are distinct from the processor as an organization. So that distinction needs to be made. Article 33 then deals with notification of a data breach. And this is a big deal. This is one of the main provisions in the GDPR, and this is one of the few things that almost everyone takes away from the GDPR and remembers. And it's very specific. In the case of a personal data breach, the controller shall, without undue delay and, where feasible, not later than 72 hours after having become aware of it, notify the personal data breach to the supervisory authority. So once you become aware of a data breach, you have 72 hours to notify the supervisory authority. 73 hours later, you're in trouble. If the notification to the supervisory authority isn't made within those 72 hours, then you need to explain why. If the processor becomes aware of a data breach, the processor must notify the controller without undue delay. And then it's the controller's responsibility to notify the supervisory authority. The processor doesn't get 72 hours. So here we have a very specific instruction to the controller to notify the supervisory authority when there's a breach. There are also very specific instructions about what that notification will include. So at a minimum, it will describe the nature of the personal data breach, including, where possible, the categories and approximate number of data subjects concerned, and the categories and approximate number of personal data records concerned. It will communicate the name and contact details of the data protection officer. We'll talk a little bit more about the specific role of the data protection officer later, but the data protection officer is a key character in this scenario. The notification must describe the likely consequences of the data breach. As you can imagine, data controllers prefer to minimize the likely consequences. There's a risk here of putting a bit too much spin on what has happened, and often that can make things worse in the long run. The notification must also describe the measures taken or proposed to be taken by the controller to address the personal data breach, including, where appropriate, measures to mitigate its possible adverse effects. So this is one of the things you should be doing in that 72-hour window. You should be coming up with the plan of how you're going to fix this and what you can do to make it less catastrophic. So if there was a breach in password data, for example, you might decide that you're going to require all of your users to reset the password next time they log in. That's something that could mitigate the possible adverse effects of that. So that would be quite specific to the nature of the breach. Article 33.4 provides for the information being provided in phases so that there is less delay. So the controller might decide to inform the supervisory authority very quickly and provide the other information as time goes by. And of course, any personal data breaches need to be documented. So when there's a data breach, there's some very specific communication activities that have to occur and some very specific documentation activities that have to occur. And of course, this is on top of all of the technical issues that will need to be resolved. So some technical people might be running around panicking and the data protection officer will be there looking for paperwork. But that will be required for compliance. Article 34 deals with the communication to the data subject about the data breach. So in addition to notifying the supervisory authority, the data subject will likely need to be informed also. When the personal data breach is likely to result in a high risk to the rights and freedoms of natural persons, so we've seen before that means people, then the controller shall communicate the personal data breach to the data subject without undue delay. So if there's a big risk to the data subject, then notification of the breach should happen pretty much right away. So if the security measures on your bank account have been compromised and people can get access to your money, you need to know about that right away. If the data breach might result in someone knowing that the data subject does an awful lot of dry cleaning, well, that's not a high-risk situation. Article 34.2 specifies that the communication shall describe in clear and plain language the nature of the personal data breach and at least provide the information and measures that were specified in Article 33, B, C and D. B is the name and contact details of the data protection officer, C is the likely consequences of the personal data breach, and D is the measures or proposed measures taken to mitigate the adverse effects. So at a minimum, that needs to be communicated to the data subject. Article 34.3 specifies that there are scenarios in which communication to the data subject is not required. One of those is if the controller has implemented appropriate technical and organizational protection measures, and those measures were applied to the personal data affected, in particular those that render the personal data unintelligible to any person who is not authorized to access it. So if there was a data breach but the data was encrypted, well, that's one of the scenarios where you don't necessarily have to tell the data subject. It could be that the data was pseudonymized. That might be another scenario. Another scenario in which the data subject need not be informed is where the controller has taken subsequent measures which ensure that the high risk to the rights and freedoms of data subjects are no longer likely to materialize. So perhaps some technical measures have been deployed to resolve the problem. Perhaps the login procedures have been changed. Perhaps credentials that were issued are no longer valid. Article 34C provides that the data subjects need not be advised when it would involve disproportionate effort. Now, I think it's a very brave data controller would go back to the supervisory authority and say, you know, there was a data breach and lots of data got out and it was high risk and we thought about informing the data subjects, but it just seemed a bit like too much work. That probably wouldn't go down well. So it's a brave data controller that might rely on this one. Article 34.4 states that if the controller has not already communicated the personal data breach to the data subject, the supervisory authority may require it to do so. Or it could decide that the conditions referred to in paragraph 3 there are met. So irrespective of what the data controller thinks, the supervisory authority might have an opinion too and instruct it to go one way or the other. Many organizations have very specific plans of what's going to happen if there's a security issue. And these plans often focus exclusively on the technical issues. But there are also very specific communication requirements, and these need to be embedded into the response plan. Very specific communications will have to occur, and very specific information and documentation will be required.